And in beautiful language, Justice Chinnappa Reddy said, our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Today's subject is one which concerns democracy at its absolute core level. Many people have always assumed that freedom of speech somehow goes back to Magna Carta. Magna Carta is of the year 1215 AD. And they assume that because of clauses 39 and 40 of Magna Carta, from which at least justice and liberty in the Anglo-Saxon world springs. But as a matter of fact, freedom of speech comes down in the Anglo-Saxon world to a much, much later era. Magna Carta was essentially at that time a struggle between King John and his nobles. Parliament was not the institution we know it to be. And it took many centuries before Parliament itself developed into the institution that we know it to be. So the stage really for freedom of speech was set in 1689 for the first time, when the Bill of Rights was enshrined in the reign of the first Dutch king that England ever had, William III, and his cousin consort Mary II. This was on James II, one of the most dictatorial monarchs, being expelled from England without a shot being fired. And in this Bill of Rights of 1689, freedom of speech was not spoken of as belonging to the citizen. It was spoken of as belonging only to parliamentarians. So that freedom of speech was guaranteed in Parliament, which was a very important thing at that time. Because Charles I, a couple of years, 50 years earlier, had picked up persons from Parliament and dissolved it. So that freedom of speech has its first beginnings only in Parliament. It took another century for the citizen to be given this right, or for this right to be recognized as against the state. And it happened in the French Revolution, which, as you all know, took place in 1789, exactly 100 years after this Bill of Rights. And somehow or the other, the 1789 Declaration of the Rights of Man in France specifically spoke of freedom of speech and said that it could only be curbed in the interest of public order, something very, very interesting when we come to our constitution. And of course, other abuses which will be laid down by law. 2 years later, the US Constitution, which had already been promulgated in the same year, 1789, had a Bill of Rights attached to it by its first amendment. And the very first clause of that first amendment spoke of the freedom of speech in absolute terms. This is also interesting. And this time it was in absolute terms against Congress, that is against the central legislature in the United States. So it said, Congress shall make no law abridging the freedom of speech and press. It took many centuries for us to throw off the British yoke. And when we did, in our constitution in 1950, we declared ourselves first to be a sovereign democratic republic in our preamble. And we made it clear that what was important in a democracy and a republic, as opposed to British rule, was the fact that now there would be universal adult franchise, and we would be headed by a president who is elected and not a monarch. The important thing to note is that this is done through the medium of liberty of thought and expression, specifically mentioned also in the preamble. So, armed with liberty of thought and expression, our founding fathers laid down in Article 19(1)(a) in the Fundamental Rights chapter, or chapter 3 of our Constitution, the fact that every Indian citizen shall have the freedom of speech and expression. At that time, speech and expression could be curbed only under Article 19(2). As it originally stood, it was a very peculiar article, because the very next right that is spoken of is the freedom to assemble peaceably, which is Article 19(1)(b). And that was controlled by the succeeding clause to 19(2), which is 19(3). And 19(3) said that when it comes to freedom of assembly, the legislature may make laws which are reasonable restrictions in the interest of public order. The same expression used in the Declaration of Man of 1789. Each one of these three expressions was missing from Article 19(2) in the beginning. So Article 19(2) said a law could be made curbing speech, provided it fell under four categories. The first would be security of state, the second would be defamation, the third would be decency or morality, and the fourth would be contempt of court. Now in 1950 itself, two judgments of seminal importance were laid down by our Supreme Court, consisting of 6 judges each. Because at that time in 1950, though the sanction strength was 8, the court started off with 6, so it was the full bench really that heard both these cases. The first was the case of Romesh Thapar versus the state of Madras. Patanjali Shastri J, speaking for the court, was confronted with a particular Madras Act which banned circulation, or allowed the banning of circulation, of newspapers, weeklies, etc. in the state of Madras. And Romesh Thapar was the owner, editor, etc. of Crossroads, which was published in Bombay and printed all over, including the state of Madras. And by a notification made by the state of Madras under that Madras Act, there was a complete ban imposed on the circulation of this particular weekly in the state of Madras. The Supreme Court had no difficulty striking down this section, to section 9(1)(a) of that Madras Act. And its reasoning essentially was that unlike 19(3), which I just spoke about, there was no public order exception to freedom of speech. The only exception was security of state. And security of state is at a much higher pedestal. Public order would, for example, be a riot of a local nature. Security of state would go to the security of India itself. And as avowedly this 1949 Madras Act was made so as to curb public disorder, they said public order is not an exception to Article 19(1)(a). So the section is struck down. However, they didn't stop there. They made some very, very important observations on freedom of speech, which are of extreme relevance today. First, they said, circulation of ideas is at the heart of freedom of speech. Second, they went on to say that it is very important to link freedom of speech with democracy. Because unless political discussion is free, there is democracy only in name and not in reality. And the third thing they did was, they noticed an interesting judgment of the US Supreme Court in Neer versus Minnesota, a 1931 judgment, which dealt with what the US Supreme Court called prior restraints on free speech. And the Supreme Court said that the prior restraint on free speech can happen only in very narrow and stringent limits. And in exceptional circumstances such as war, for example, or where there is incitement to violence, things of that nature. And one beautiful observation of Chief Justice Hughes in that judgment was that it is better to let the noxious branches of the tree of freedom of speech to their luxuriant growth rather than to prune them. Because in pruning them, one may well also prune the branches which give fruit. Now, with all these observations, the very first Supreme Court put freedom of speech on a pedestal. In the companion judgment in Bhushan versus State of Punjab, there was an East Punjab Act, which this time required any newspaper or article to first be censored by government before it could be circulated. This was again struck down on the same ground as the ground in Romesh Thapar, because the East Punjab Act also was a public safety or public order act. And since public order was no exception to freedom of speech, it was struck down on this ground itself, and the observations in the first judgment were reiterated. Only one learned judge, Justice Fazal Ali, dissented. Immediately upon these two judgments being declared, came our First Amendment. And our First Amendment was piloted by Jawaharlal Nehru even before he was elected. Because if you remember, the first elections took place in 1952. And the then Constituent Assembly continued as a provisional parliament. So the provisional parliament tabled this First Amendment. The very first thing that this amendment did insofar as Article 19.2 was concerned was to bring it in line with Article 19.3. So that now you had reasonable restrictions first. So there was a balancing act that you required to do. And it said, in the interest of, this is again an important expression, because the earlier expression was in relation to, much wider. So there must be some close nexus between, therefore, the governmental activity curbing free speech and the subject matters laid down. And it added 3 more subject matters to the 4 subject matters already there. Very first, obviously, being public order, which was missing. The other being friendly relations with foreign states. And the third being a very important, again, pointer to what can and cannot pass muster: incitement to an offense. A little more about the word incitement. Because when we speak of discussion and advocacy, they are very different from incitement. You must actually incite somebody to do something before you can curb free speech. It's only in 1963 finally that one more category was added, namely the sovereignty and integrity of India. So 19.2 therefore was brought online largely following what was stated by the majority judgments in Romesh Thapar and Bhushan. One other very interesting thing happened. The First Amendment had a kind of constitutional black hole. Namely, it had Article 31B added, capital B. And Article 31 capital B in essence stated that the moment there is any act either of the central legislature or of the state legislatures put into the black hole, which is the 9th schedule to the Constitution of India, then notwithstanding that the section may have been struck down and notwithstanding that it may have violated any fundamental right, it comes back to life. Interestingly enough, land reform legislation formed the first 10 entries of this black hole. But neither the Madras nor the East Punjab Act were put into it. Matter of great importance. So, the legislature was cognizant of the fact that though public order was missing, there were other observations made on free speech which gave it this preferred status, and that therefore these two acts did not deserve any protection that the Land Reform Acts got. So immediately a distinction was made between free speech or liberty and property. Now, armed with this, as a matter of fact, Virendra versus State of Punjab is a 1958 judgment. And a Punjab Act, which contained the section 3, which was almost exactly in parametry with the Madras Act in Romesh Thapar, was also struck down, and this time under the new 19.2. So that despite the fact that public order was there as an exception, they found that a blanket ban of circulation, because even in that case, the Daily Pratap and the Veer Arjun, which were published in the Punjab, were banned from entering Delhi. Same kind of thing that was done in Romesh Thapar. They said that blanket ban is anathema to free speech and must go. Also, when it came to pre-censorship, the later judgments, one in K.A. Abbas's case in 1971, detailed judgment, Justice Hidayatullah, and a later judgment in Anand Patwardhan's case, also went the whole hog in saying that censorship is also to be in very narrow and stringent limits. And in Anand Patwardhan in particular, which was a case where a director, Anand Patwardhan, wanted a particular movie broadcast over Doordarshan, which was the only means in those days of getting through to the public on television. And the Doordarshan repeatedly refused to broadcast. The movie essentially was on how women are treated, and in particular, how degrading and horrible sati is, because Roop cover at that time had been pushed into a funeral pyre. So the film depicted all this. And finally, the Supreme Court said that if you want to censor something, you must first apply what is called the average person's contemporary community standards test. The average person will be a person who is of robust intellect, not some weakling. Second, you will view the film as a whole. You won't take one small part of it and say this offense or that offense. See it as a whole. Then you will see as to whether there is anything patently offensive in terms of obscenity. And if there is, however, literary or artistic merit in this, then even then it must be allowed. And one other very important observation made in that judgment was that the freedom of speech is freedom both ways. One to communicate ideas, one to receive ideas. And the receipt of ideas can be from any corner of the world. Very important. Because when we come to what is happening today, there's going to be a comment on this. Now, after these judgments laid down, pretty much that bans are anathema, censorship is anathema. What exactly do we say is the content of this right? Because it's a right which must have some content. As I said earlier, the very first thing in the right is the right to communicate freely ideas of any kind. It doesn't have to be political only. It can be ideas of the widest kind. The second and equally important right is this right to receive those ideas. And the third is that there can be no coercion by the state for a person to speak. That's equally important. So the negative concept of not being coerced into saying something you don't want to say. Now, as examples of each of these things, we first go to some of the flag cases in the United States. In Stromberg versus California, which is a 1931 judgment, by a 72 majority, because there they sit en banc as 9 judges always. There was a red flag, which was the communist flag, which was being paraded around in the streets of a particular city, and people shouting slogans. And the question was as to whether this is permissible within the free speech contained in their constitution. And the court had no problems in saying, of course it is. Because what is most important is to remember that our constitution, that is the US Constitution, believes in orderly, peaceful change in government. And this can never happen unless there is a political discussion of all hues in the so-called marketplace of ideas, so that people may choose the next government. The other fact case is a remarkable case, Texas versus Johnson, which is a 1989 judgment. Here, by a razor-thin majority of 5-4, the two ends of the Supreme Court as judges, Justice Scalia and Justice Brennan, met together to form the majority. This is the only time. Otherwise, Justice Brennan was the great liberal and Justice Scalia was the originalist. And they were confronted with something fantastic, which is that a person actually burned the US flag outside the courthouse of Denver as a protest against the Reagan administration and as a protest against Reagan standing for the second time. Now, ordinarily one would have said burning a national emblem like this is something that is anathema, you just cannot do it. No question of freedom of expression here. But strangely enough, 5 people said, yes, you can. Because what you are really seeking to do is not to offend people. They also added very hastily that as a matter of fact, there was no violence on the burning of that flag. But they said what you are trying to do is not merely to burn the flag and denigrate the United States. What you are trying to do in burning that flag, and you made it clear by your speech, was to say that America is not a country worth living in if President Reagan comes in again. I have grave doubts that our courts will go to this extent, but it only shows you to what extent the US, a democracy which is now 220 years old and mature, can go to, again by a razor-thin majority. Now, apart from these judgments, when we come to the right not to be coerced into speech, you come to what is called the Jehovah's Witness cases. Now, the Jehovah's Witness, as you know, is a small religious minority group, Protestant group. And they have this belief, it's an ingrained and genuine belief, that organized religion is a grave crime and something which should be done away with immediately as the work of the devil. They also believe that, as the Bible said, you cannot bow to any graven image. So, one of the things that was tested was in the famous Gobaitis case in 1940, where children from this Jehovah's Witness sect in schools refused basically to bow to the national flag. And an 8-1 majority held that no, sorry, this is going too far. The flag, after all, is the emblem of America. If it's the emblem of America, everybody must get up and salute it. And you people not getting up and not saluting it is not something that can be tolerated in the name of nationalism. Justice Stone was the sole dissenter. Surprisingly, within 3 years, another Jehovah's Witness case came with exactly the same facts, and this time by a 6-3 majority, they reversed that judgment in the West Virginia board case versus Barnett. And Justice Jackson, this time speaking for the majority, said 2 very, very important things where free speech is concerned, and it's been oft quoted in many of our judgments. The first thing that he said was that freedom of speech does not depend on votes or elections. It has been put away from majorities, put away from officials. Most important to remember. And the second thing he said is that if there is one fixed star in our constitutional constellation, it is this: that no official, high or petty, can prescribe what is orthodox in matters of politics, nationalism, religion, or other matters of opinion, quote unquote. A very strong judgment by a very brilliant judge. You'll remember Justice Jackson was perhaps the only sitting Supreme Court justice who ever left his robes behind in America and became public prosecutor at the Nuremberg trials. And the entire Nuremberg trial, as a matter of fact, revolved around his person. And he came back and took his seat again in the United States Supreme Court, but unfortunately lost the Chief Justiceship because of certain other circumstances. So in these ringing words, we have these two Jehovah Witness cases, and we have our own Jehovah Witness case as well. In this country, in Bijo Emmanuel's case in 1986, again this same little religious minority came forward and said that we will not sing the national anthem. We will get up respectfully, but we cannot sing it because of our religious beliefs. Again, our Supreme Court came to their rescue, following all these American judgments. And in beautiful language, Justice Chinnappa Reddy said, our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Beautiful words. And with that, he allowed these children to get up respectfully and not sing along with the other children.